The inspiration for the book and obviously this talk as well is an incident that occurred 14 years ago now. I was a speaker at Texas Tech University Law School. I was invited to talk on the issue of public education, religion, and some of the controversies concerning the teaching of science. And after my talk, one of the members of the audience, a professor at the university, he didn't ask me a question. He raised his hand and stood up and said, "Thank you for your lecture, but all you've given us are religious arguments." And I replied, "I'm relieved. I thought you were going to say they were bad arguments." And so it got me thinking about, what's going on in law, politics, discussions about contested questions in which one can say that a view, just by simply labeling a view religious, that in and of itself somehow takes it out of the realm of rational discussion. And from there, I published several articles and eventually the book that came out last year. So what I'm going to do this afternoon is, in order to kind of drive home this point, and the point that I want to make is that there's really no principled reason why religious arguments ought to be excluded from the public square. But in order to show that why I think this is the case, I'm going to first go over two different types of controversies in the public square, and then conclude by introducing to you some of the work that's been going on in the legal literature dealing with the relationship between faith and reason in the public square, and leave you with a kind of an encouragement as philosophers, and especially Christian philosophers, to maybe think about writing in law reviews. My own background is both in philosophy and law. I have a PhD in philosophy as well as a law degree, so I try to navigate in both worlds. And so one of the things that I've discovered is that much of what is written in the legal literature, especially dealing with issues of faith and reason, are just not very good. They ignore much of the literature that's been produced in the past 50 or 60 years in the world of philosophy of religion, not to mention metaphysics and epistemology. So what I want to do this afternoon is to bring this to your attention. And to do so, I want to first go over two issues, and there's going to be some discussion of legal opinions, and at points I'm going to attempt to explain some of the things that the judges and justices are doing, and then we'll move on and talk about how some of the folks in philosophy of law have talked about these questions. So the first thing I want to talk about under the general heading of religious liberty and what counts as reasonable is the recent case that was issued by the U.S. Supreme Court in 2014 called Hobby Lobby versus Burwell. It's a wonderful case for this lecture because in both the dissenting and majority opinions, you have, I think, misunderstandings of the nature of religious belief, as well as a kind of insight to see how judges deal with questions of religious liberty and when they conflict with generally applicable laws. Let me tell you a little bit about the case. It was a case in which the Supreme Court ruled in a 5-4 opinion that two closely held family-owned businesses, Hobby Lobby and Conestoga Wood Specialties, both of which objected to a regulation issued by the Secretary of Health and Human Services under powers given to her by the 2010 Affordable Care Act. All I'm saying here is that the law that they apparently ran afoul of was really a regulation, not actually part of the Affordable Care Act. This regulation required for-profit businesses to include in their employee insurance plans birth control methods that the company's owners believe may at times function to destroy human embryos soon after fertilization. The Hobby Lobby owners, members of the Green family, are evangelical Protestants, while the Hans, owners of Conestoga, are Mennonite Christians. For this reason, the companies argued that because the HH regulation required that they directly pay for and thus cooperate with the use of a product that violates what their respective theologies teach them about the sanctity of human life, the regulation is in violation of the 1993 Religious Freedom Restoration Act, which is sometimes called RFRA. Now, in order to grasp the significance of this case for religious liberty, I'm going to kind of give you an illustration outside of this debate. Imagine, for example, that publications supported by the research arm of the National Rifle Association, rather than those of Planned Parenthood. And I mention this because if you read the HHS regulations, if you look at all the footnotes, the justification of the regulations is based on literature produced by the Guttmacher Institute, which is the research arm of Planned Parenthood. So imagine the research arm of the NRA were employed to help the Secretary of HHS in creating regulations for the Affordable Care Act. Believing that self-defense saves lives and that an armed citizenry advances that good, the NRA data convinces the HHS Secretary to require all employers to include in their employee health care plans 2 firearms, including free bullets depending on need. Quaker families that own for-profit businesses object on the grounds that it would involve them in directly providing instruments of war to their employees in clear violation of their pacifist beliefs. The Quakers suggest that the government itself can give these weapons directly to the employees without involving the Quaker business owners in the activity. The government rejects this suggested accommodation and proceeds with the policy anyways. This is followed soon after with the Quaker business filing a lawsuit against the HHS secretary. Now, in the real-life Hobby Lobby case, the religious business owners were ultimately victorious. Writing for the majority, Justice Samuel Alito relies on RFRA, something I've already mentioned, the federal law that was passed in response to the 1990 case, Employment Division versus Smith. There's a little history here. In Employment Service versus Smith, what happened, there were 2 gentlemen that were part of the Native American church. They were drug counselors, but part of being a member of the Native American church is the smoking of sacramental peyote. They were subsequently terminated from their employment, and they were then denied unemployment benefits since they were fired for cause. And they wound up suing under the free exercise clause of the First Amendment. And in a very famous opinion, Justice Antonin Scalia said that a generally applicable law that's neutral, that happens to burden religious belief, does not violate the First Amendment. And so that actually caused this big kerfuffle in the public culture, and it was one of the last times, at least in my memory, in which you had people across the political spectrum joining forces and passing almost unanimously in Congress the Religious Freedom Restoration Act, signed by President Clinton. RFRA was actually overturned for state laws in a subsequent opinion called the City of Burney, involving a Catholic parish that wanted to renovate, and the parish had been declared the building was a historic landmark, and so they weren't allowed to renovate. They sued under RFRA and they lost. But the Supreme Court actually didn't deal with whether RFRA applied in federal cases. So the HHS mandate is a federal case, and so the court heard the case. So the relevant part of RFRA for the Hobby Lobby case is this, quote, government may substantially burden a person's exercise of religion only if it demonstrates that application of the burden to the person, 1, is in furtherance of a compelling government interest, and 2, is the least restrictive means of furthering that compelling government interest. What RFRA is saying is essentially this: if you're going to pass a law that's generally applicable and neutral, you better have a really, really good reason if you're burdening people's religious free exercise, and there has to be no other way you can get what you want except the way that you have it in the law. So basically what RFRA does is it shifts the burden from the plaintiff to the defendant. That is, in this case, it's the U.S. government. So, according to Justice Alito, the HHS mandate at least violated number 2. That is, the the government could get those contraception devices and pharmaceuticals to people without doing it through businesses. In other words, there was another means by which they could do that. Now, another question that came up in the opinion, which is important, although not necessarily relevant to what we're dealing with here, is the issue of whether businesses are legal persons, and Justice Alito deals with that. As far as the first, whether the HHS mandate fulfilled a compelling government interest, Alito said we don't have to deal with it because this mandate violates the second prong. My own suspicion is that the reason why he didn't go for 1 and 2 is that they wouldn't have gotten Justice Kennedy's vote. Because I think Justice Kennedy actually believes that there is a compelling state interest. So, all right. So, now, for our purposes here, this is, I want to quote here from a portion of the opinion in which Justice Alito talks about the business owner's objection to the mandate. He says, quote, "The owners of the businesses have religious objections to abortion, and according to their religious beliefs, the 4 contraceptive methods at issue are abortifacients. They have a sincere religious belief that life begins at conception," unquote. Now, I think that's true enough in the sense that, yeah, that's exactly the argument they made. But I think that on another level, it sort of diminishes the intellectual credentials of the position held by the business owners. Now, to better grasp this point, we're going to contrast Alito's opinion with those offered by his colleague, Justice Ruth Bader Ginsburg, in her dissent, to which she offers examples of other religious beliefs that sincerely devout business owners may hold. For philosophers who write in this area, or write in the area of applied ethics, this sort of counterexample way is very familiar. So this is what she says. Would the exemption the court holds RFRA demands for employers with religiously grounded objections to the use of certain contraceptives extend to employers with religiously grounded objections to blood transfusions, Jehovah's Witnesses, antidepressants, Scientologists, medications derived from pigs, including anesthesia, intravenous fluids, and pills coated with gelatin, certain Muslims, Jews, and Hindus, and vaccinations, Christian Scientists, among others? According to counsel, that is a lawyer for Hobby Lobby, each one of these cases would have to be evaluated on its own, applying the compelling interest, least restrictive alternative test, that is the RFRA test. Not much help here for the lower courts bound by today's decision, unquote. As should be evident, Justice Ginsburg raises these counterexamples precisely because they are based on beliefs, at least in my judgment, that would seem to most people to be prima facie unreasonable. Although, as she notes, Hobby Lobby's counsel appealed to RFRA's compelling interest, least restrictive means test as the limiting principle that would allow future courts to thwart such counterexamples, she is not convinced of its judicial workability. And this is another quote from her dissent. She says, "For there is an overriding interest in keeping the courts out of the business of evaluating relative merits of differing religious claims, or the sincerity with which an asserted religious belief is held," unquote. She also sees this as a possible establishment clause problem. That is, the part of the First Amendment that says that the government shall not establish a religion. So she says that not only is there a sort of free exercise issue, how are the courts going to deal with who gets the accommodation? The other is this. She says it because, quote, approving some religious claims while deeming others unworthy of accommodation could be perceived as favoring one religion over another. But it's not clear how the judiciary can avoid evaluating the merits of differing religious claims and practices when dealing with claims and practices that dissent from dominant cultural understandings. Consider, for example, the cases involving creation and intelligent design, ordinances that forbade Santeria animal sacrifice, the Amish and compulsory education, the Mormon practice of polygamy, and non-theistic conscientious objection. The point of bringing up these cases to bear on this analysis is not to suggest they are analogous to the Hobby Lobby case. Rather, it is to show that the courts do in fact evaluate in differing degrees the reasonableness of the religious beliefs and practices in question to the extent to which those beliefs and practices impact a variety of legitimate state interests. In fact, none of these cases could have been resolved without judicial evaluation of the merits of religious claims and practices and their effect upon the common good. In, for example, the Santeria case, some of you may be familiar with this case, the Supreme Court held that a law that was not generally applicable or neutral, that targeted religious practice, was unconstitutional unless it survived strict scrutiny. Now, what does that mean? Strict scrutiny is a standard that courts use when a fundamental right is at stake. So supposing we pass a law that says you can't yell fire in a crowded theater when there's no fire. That limits your freedom of speech, but there's a really good reason for that, and so it passes strict scrutiny. The Santeria case is interesting because it's a religious group that's a kind of combination of kind of Catholic liturgical practices and voodoo. So an unusual religious group that arose in the Caribbean. And a lot of immigrants from the Caribbean practice Santeria, and it includes animal sacrifice. And so the problem that the city of Hialeah had is that they wanted to ban this because they didn't like it. On the other hand, though, there were butchers and a large segment of Jewish citizens that practiced kosher killing of animals. So how were they able to resolve this? And so what they did is they wrote the statute in a way that sort of gerrymandered out the Santeria folks. And so the court said that their motivation was to sort of target the religion, right? So that's why the court didn't uphold the ordinance. Now, in order to engage in that assessment, a court would have to figure out if the government's interest is compelling. But how can one do so without at some point evaluating the merits of the religious claim in question? After all, it makes a difference whether the law under scrutiny is criminalizing the use of communion wine or child sacrifice. In other words, whether the government's interest is compelling depends on prior background beliefs of reasonableness held by the judges and the justices. In each of the cases I've mentioned, the courts and the attorneys who argued the cases employed non-revelatory beliefs in order to determine or defend or critique the reasonableness of the religious claims and practices in question. What I mean by non-revelatory beliefs are beliefs that don't come from what one may believe is divine revelation. In the creation, science, and intelligent design cases, for example, they involve the question of whether public school science curricula may include these views. And the court decided no, because they were non-scientific. That the theories just they shouldn't be in public schools, and so therefore the people that supported them were clearly motivated by their religious belief. I've already mentioned the Santeria case. The Amish case, it's a 1972 case called Yoder versus Wisconsin. The Amish wanted to be exempted from compulsory education for their children after 8th grade. And the court carved out the exemption, and the court said, look, here's a quote from the opinion. The Amish, quote, succeed in preparing their high school-aged children to be productive members of the Amish community. Their system of learning through doing the skills directly relevant to their adult roles in the Amish community is ideal and perhaps superior to ordinary high school education. The evidence also showed that the Amish have an excellent record as law-abiding and generally self-sufficient members of society, unquote. The federal prohibition of polygamy in the territories, which is a 19th century case, according to the court, does not violate the Free Exercise Clause because the Constitution allows Congress to criminalize actions even if they arise from religious warrant if those actions are, quote, in violation of social duties or subversive of the good order, unquote. In the non-theistic conscientious objection cases, those were cases in which several people wanted to be exempt from compulsory military service, but the federal statutes talked about belief in God. And so they apparently wouldn't be able to receive the accommodation under that, but the court said this. They said the atheist, the objector, beliefs, quote, certainly occupy in the life of that individual a place parallel to that filled by God in traditionally religious persons, unquote. Now, whether or not the court in each case vindicated the religious belief and practice in question, it was clearly guided by non-revelatory standards of reasonableness. Appealing to mere belief was certainly not enough, even though, as I'll note in a few minutes, there's a dominant stream in judicial thought that treats religious belief as not amenable to reason. Courts nevertheless still have to determine the extent to which religious liberty or establishment ought to be tolerated under the First Amendment or the Religious Freedom Restoration Act, based on standards of reasonableness that seem to be assumed rather than argued for. Thus, to treat all religious belief as merely religious beliefs, as Justice Alito seemingly does, or to maintain that courts ought not to evaluate the merits of competing religious claims, as Justice Ginsburg claims, is just not possible. Courts will, whether one likes it or not, issue judgments about religious claims and practices that are guided by unchallenged assumptions of what counts as reasonable, including what counts as the public good. This is why those who hold beliefs like those held by Hobby Lobby's owners cannot ignore the power of the received cultural understandings of reasonableness on the intellectual formation of judges. That understanding, as I've argued elsewhere, assumes that the issue in dispute is really a matter of two allegedly incommensurable subjects, faith and reason, rather than a matter of two contrary answers to the same question. And so in the Hobby Lobby case, the issue was framed, at least the way I read the opinions, as sort of faith versus reason. And instead of being two different answers to the same question, it's treated as if it's two different subjects. And so what I argue in my book is that it's actually really a debate between two answers to different subjects, or the same question, namely, is the embryo one of us? That's the question, and that's the dispute. It's not, I think, between faith and reason. It's actually, another way of putting it, actually a conflict between two different understandings of reason. This is why Justice Ginsburg and a generation of young lawyers, some of whom will someday sit on the federal bench, see Hobby Lobby's beliefs as outside rational discourse. If the friends of Hobby Lobby do not rebut this understanding by making the argument in those venues outside the courtroom that really shape judicial reasoning, such as in the culture and in the law schools, a future court may conclude, as it would with a Christian Science business owner, that a sincere belief is just not enough. The fact that a particular law, such as the HHS mandate, burdens the religious liberty of a closely held family-owned corporation, an individual citizen, or a nonprofit, is a necessary condition for the plaintiffs to charge the government with violating RFRA. But that is not enough. Even though in a RFRA case the legal burden is on the government, the cultural burden, whether one likes it or not, is on the plaintiff and his advocates. Thus, one not only has to show that his religious beliefs is substantially burdened for legal purposes, one must also show that one's religious beliefs are reasonable, whether that means intrinsically reasonable or reasonable for the state to tolerate given its legitimate interest in the common good. Now I want to move on to another, actually a cluster of cases that have been issued by state courts over the past 2 or 3 years, and these involve religious liberty claims and same-sex marriage cases. These cases involve owners of private businesses who refuse to materially cooperate with the performance of a same-sex wedding in jurisdictions that prohibit discrimination based on sexual orientation. Now, the most well-known cases have concerned a baker in Colorado, a photographer in New Mexico, and a florist in Washington State. I should say here that we're going to kind of change gears in these cases. In the first case, the Hobby Lobby case, I think, is an example of treating religious beliefs, or at least one type of religious belief, as not amenable to reason. Here, I think the problem is with the courts is not understanding what, for example, religious believers believe about an institution like marriage. So here it's actually more of a rite, R-I-T-E, or if you're within a particular theological tradition, a sacrament. In each case, the proprietor declined to do business with a gay or lesbian couple who tried to procure their services for a ceremony or event that celebrated the couple's wedding. The courts in every case ruled in favor of the complainant couple, maintaining that the proprietor, by declining service, discriminated against the customer based on his or her sexual orientation in violation of the jurisdiction's anti-discrimination law. Although the owners in each case offered overlapping accounts of what grounds their religious liberty claim. In each of these states actually had a state RFRA, and so each defendant in this case gave different sorts of arguments. But their arguments aren't really important to the point I'm trying to make. What is important is to see how the courts in these cases missed, or I think missed, the actual question over which the owners and their legal adversaries disagree. In all three cases, the defendants, the baker, the photographer, and the florist, argued that they had not, in fact, violated the anti-discrimination laws, since their decision to decline service was based on the nature of the event with which they were being asked to materially cooperate and not on the sexual orientation of their prospective customers. Yet the courts rejected that argument. And here's a quote from the New Mexico Supreme Court, which actually winds up being quoted in the other two cases. Quote, "When a law prohibits discrimination on the basis of sexual orientation, that law similarly protects conduct that is inexorably tied to sexual orientation," unquote. I think this reasoning is specious, not because it may not be a reasonable construal of the jurisdiction's anti-discrimination law, but because it does not take rights seriously. It assumes that a wedding is simply a type of conduct, quote, "inexorably tied to sexual orientation," to quote the court again. That may be how some people understand weddings, just as some people think of marriage as just a piece of paper or a good investment. I actually looked that up, and there's Forbes magazine has a whole series of articles on why marriage is a good investment. So to sort of satisfy your inner utilitarian. But for many or most citizens, weddings, like baptisms, bar mitzvahs, burials, and ordinations, are inexorably tied to a transcendent reality to which these events point and by which they are imbued with meaning and significance. For those citizens, an authentic wedding, whether civil or sacramental, marks the beginning of a natural marriage, and that participates in the eternal law through the natural law. That's the way Thomas Aquinas would put it, and some other those in other traditions. Thus, for the civil law to require that such citizens either materially cooperate with what they believe cannot in principle be a natural marriage or suffer massive financial penalties seems almost a paradigmatic case of what Thomas Jefferson had in mind when he wrote this, quote, "No man should be compelled to frequent or support any religious worship, place, or ministry whatsoever, nor shall be enforced, restrained, or molested, or burdened in his body or goods, nor shall otherwise suffer on account of his religious opinion or belief," unquote. To see why this is so, consider the fictional case of Russell Less. It's fictional, it doesn't matter, does it? Russell Less. I have a friend, Russell Moore, who's a Southern Baptist, so this is why it's kind of based on. Russell Less, a professional photographer who happens to be a devout Southern Baptist. One of his clients, Aristotle Jones, who is Greek Orthodox, tells Russell that he would like to hire him as a photographer for the baptism of his newborn son, Socrates. As a Southern Baptist, Russell holds to the doctrine of believer's baptism and thus does not believe that the baptism of Socrates would be an authentic baptism. In fact, if Socrates were to become a Southern Baptist in his teenage years, Russell would tell him that his infant baptism did not count and that he would have to be baptized again. Russell tells Aristotle that he would be more than happy to photograph the entire Jones family, either individually or collectively, in or near any body of water, including pools, rivers, streams, oceans, seas, and gushing fire hoses. However, Russell explains he cannot materially cooperate with the performance of a ceremony in and near water that he is convinced is not what Aristotle and his family think it is, an authentic baptism. For Russell, as with Aristotle, baptism is a practice required by his faith because it was commanded by Christ. However, as Russell understands that command, only believers can be baptized and babies aren't believers. He admits to Aristotle that other Baptist photographers may have a different opinion on whether they would participate in the ceremony, but he cannot in good conscience do so. Aristotle thanks Russell for his candor and friendship, and a week later finds a Catholic photographer who is more than happy to take pictures of Socrates' baptism. Except for its neighborly ending, this story is almost perfectly parallel to the same-sex wedding cases. This is because for most citizens, a baptism, like a wedding, has transcendent significance even if some of the participants, attendees, or observers cannot see it that way. as in the case of a baptism where some of the attendees view it as no more than a perfunctory tradition. A judge who takes rites seriously would easily be able to distinguish Aristotle's religious beliefs from his liturgical practices, just as the judges in the same-sex wedding cases, at least I think, should have been able to easily distinguish the plaintiff's sexual orientation from the ceremonies they believe solemnize their unions. Now, to be sure, our public questions become more complicated and our adversaries more difficult to caricature when we think this way, but I think that justice demands nothing less. So let me move on now finally to what's out there in legal scholarship. Here I want to go over the writings of three writers, one of whom has recently passed away, Stephen Gay, and Susanna Sherry and Brian Leiter. So I'm going to begin with Stephen Gay, and here I don't have much time for critique, and as most of you will recognize as I go over what they say, you're going to be astonished I think you're going to be astonished at what they say, and many of you are going to bring to mind a lot of philosophical literature that you have been working on yourself, and be amazed that legal scholars aren't aware of this. So I want to begin with Stephen Gay. Stephen Gay writes that the separationist view of the Establishment Clause, now what he means by that is the view that we should interpret the Establishment Clause of the Constitution in a really in a way that there's a complete and total separation of not only church and state as institutions, but religious citizens and the public square. Not that religious citizens can't actually participate, but they cannot use or bring to bear and under their public arguments anything that remotely touches on their religious beliefs. They can offer secular arguments, a kind of quasi-Rawlsian approach, but it's actually much tougher than that. This is what Gay says. He says, concerning politics, quote, in a proper democracy, religion should be primarily a private phenomenon because religion and politics are simply incompatible. This is because, writes Gay, quote, religion is particularly ill-suited to the sorts of pressures and influences that define the political process, combining the typical political phenomena of personal greed, self-aggrandizement, duplicity, log-rolling, deal-making, and unprincipled compromise with the typical religious phenomena of theological certainty, absolute moral dictates, and the threat of eternal damnation creates an especially dangerous cocktail, unquote. As for religion, according to Gay, the separationist assumes, quote, it is no longer possible in the modern world to decide collectively matters that are by their nature non-rational, metaphysical, and impervious to both empirical analysis and logical proof or disproof, unquote. Given the large number of such irrational, unprovable religious perspectives embraced by citizens in our pluralistic society, Gay goes on to say, quote, the separationist perspective is that it is best for society if everyone is permitted to follow their own faith where it leads, without having to worry about their safety in the company of others who are devoted to contradictory moral and theological absolutes, unquote. Offering an account similar to Gay's is Susanna Sherry, who's a law professor at the University of Minnesota. She suggests that the relationship between church and state as embodied in the Constitution's free exercise and establishment clauses should be viewed as analogous to what she describes as the different and contrary epistemic commitments to faith and reason. Although she concedes that it may be possible to envision a religion based on reason, or wholly or partly on reason, this is a quote from her, most of the major religions in America are based on faith as the underlying epistemology, unquote. According to Sherry, this is again a quote from her, for the faithful, the ultimate authority and source of truth is extra-human, and evidence can, in some religious traditions, must be entirely personal to the individual, unquote. By contrast, for the reasonable, and she means by reasonable people that aren't religious, that is, those who follow reason, quote, both the source and evidence for the truth lie in common human observation, experience, and reasoning, unquote. A person operating under the epistemology of faith, according to Sherry, is, quote, able to ignore contradictions, contrary evidence, and logical implications. Indeed, one test of faith is its capacity to resist the blandishments of rationality. The stronger the rational arguments against a belief, the more faith is needed to adhere to it, unquote. However, she says, quote, secular science and liberal politics, both committed to the primacy of reason, necessarily deny that any truth is incontestable, unquote. Following along the lines of Gay and Sherry, although in a clearly more philosophically sophisticated fashion, Brian Leiter maintains that, quote, for all religions, there are at least some beliefs central to the religion that, one, issue in categorical demands of action, that is, demands that must be satisfied no matter what an individual's antecedent desires and no matter what incentives or disincentives the world offers up. And two, do not answer ultimately or at the limit to evidence and reasons, as they are understood in other domains concerned with knowledge of the world. Religious beliefs, in virtue of being based on faith, are insulated from ordinary standards of evidence and rational justification, the ones we employ in both common sense and in the sciences, unquote. It should be noted that Leiter's project, unlike the ones advanced by Gay and Sherry, is not primarily about the rational status of religious belief, although it plays an important part in his work, which is to make the case that religious belief is not special, and thus should not be accorded any more respect or deference in our legal institutions than non-religious claims of conscience or other personal subjective beliefs that are not subject to the standards of science or what he calls common sense. In addition, Leiter, like Sherry, uses the term faith in an idiosyncratic way. Each in their own way asserts that faith is by its very nature incompatible with reason, even though that's not the way religious believers understand faith. In the Christian tradition, for example, though faith is one of the three infused theological virtues, that same tradition for nearly 2 millennia has produced numerous sophisticated and careful works by its most important philosophers, theologians, and scholars on the complementarity of faith and reason. Not only does Leiter show no evidence of having consulted such treatises, he completely ignores what is perhaps the most widely read and influential modern Catholic encyclical on that matter, Fide et Ratio, by John Paul II. This is not to say, however, that Leiter or Sherry could not be correct in their understanding of faith, or that it is a mistake to believe that faith and reason are complementary. Rather, what I am suggesting is that if one is going to issue the judgment that a large swath of the human experience is incompatible with the deliverances of reason, one should at the very least consult and engage those who offer a contrary account. Concerning Leiter's first point, that is, where he talks about the categorical demands of action, and here he says, you know, there have been religious believers who are willing to die for their faith and who are willing to die for what he believes are good causes. So he says, it's wonderful when religious believers are involved with movements of social justice, but then again, religious believers could fly airplanes into buildings and blow up abortion clinics. We should be a little wary of people that are true believers. Now, for my present purposes, it's really two that's more important. That is the second claim where he defines religious belief as being incapable of being defended by reasons or evidence and, in a sense, unfalsifiable, or you cannot bring reasons or evidence against religious belief, that it's insulated from contrary or counter arguments. Now, he brings up three counters to number two. The first is what he calls the intellectualist traditions of religious thought. And he offers up, these are the three, he offers up Paley's natural theology, neo-Thomist arguments, and intelligent design. And he promptly dismisses them as insulated from the evidence for two reasons. First, he writes, quote, "It is dubious, to put the matter gently, that these positions are really serious about following the evidence where it leads, as opposed to manipulating it to fit preordained ends. And secondly, in the case of the sciences, beliefs based on evidence are also revisable in light of the evidence, but in the intellectualist traditions in religious thought just noted, it never turns out that the fundamental beliefs are revisable in light of new evidence," unquote. The second possible counter to two that Leiter suggests is that the believer may offer historical evidence for miraculous events she believes support the veracity of her faith. So Leiter writes, quote, "Might not a Catholic," now he doesn't say Christian here, it's kind of odd, because he said, "might not a Catholic, for example, quite reasonably appeal to testimonial evidences recorded in the Bible and elsewhere in support of her belief in the resurrection of Jesus Christ?" In my critique of this, I actually put next to it in brackets Christian, because obviously more than Catholics believe in the resurrection of Jesus. So, although he concedes that a Christian may make such an appeal, it really doesn't amount to much. And here's a quote from his book, Why Tolerate Religion? Quote, "To be sure, testimony that Christ rose from the dead is a kind of colorable evidence from a scientific point of view, that the testimony is inconsistent with everything we have reason to believe about what happens when human bodies expire, both from massive amounts of testimonial evidence as well as the evidence of physiology and biology, indicates that the ancient testimonial evidence deserves no credence at all." Unquote. It's actually, if you take that famous quote from C.S. Lewis where he says that Hume reasons in a circle, you literally could take out Hume and put in Leiter's comments, and it would actually apply exactly the same way. All right. So the third possible counter is this. He brings up Reformed epistemology, but he promptly dismisses that as well. After mentioning two of its most prominent advocates, William Alston and Alvin Plantinga, he writes that, quote, and this is from the book, Why Tolerate Religion, "I'm going to, quote, assume, uncontroversially among most philosophers, but controversially among Reformed epistemologists, that Reformed epistemology is nothing more than an effort to insulate religious faith from ordinary standards of reason and evidence and common sense in the sciences. And thus religious belief is a culpable form of unwarranted belief given those ordinary epistemic standards," unquote. There seems to be a common thread that connects the views of Gay, Sherry, and Leiter. I call this common thread secular rationalism. And on the study sheets that I passed out, this is how I define it. Religious beliefs are irrational because they are based on, one, unprovable claims in the sense that they are the sorts of beliefs that cannot in principle be proven. Two, incontestable claims in the sense that they are the sorts of beliefs that cannot in principle be falsified. And three, claims that cannot change or develop because they are insulated from the ordinary standards of evidence and rational justification, unquote. Now, in my new book, Taking Rites Seriously, I offer an extensive critique of secular rationalism. However, my point of bringing this to your attention, following my analyses of Hobby Lobby and the conflicts between religious liberty and certain anti-discrimination laws, is to encourage Christian philosophers to boldly enter the fray in legal literature. There is much work to be done, for hanging in the balance is not only the intellectual reputation of our faith, but the liberty of our churches and its members to practice their faith in all its fullness in every endeavor in life. Of course, I am well aware that even among Christians there is deep disagreement on the issues over which the parties in the legal cases I mentioned fought. But I'm not sure why that should matter to the legal question. After all, I disagree with my Anabaptist brothers and sisters that war is always wrong, but I don't think they are irrational or unreasonable in saying that war is always wrong, or I don't think they're rational holding that belief. For this reason, conscientious objector statutes seem perfectly just, even though the absence of Anabaptists in the military increases the burden on those who do not share their convictions. For example, a just war-believing Catholic citizen may wind up dying in place of the missing Anabaptist. Some Christians believe that capital punishment is intrinsically wrong. Others believe that it is immoral because under certain social conditions it is unnecessary and or inequitably applied. Suppose a Christian pharmacist who holds either of these beliefs is commanded by his state government to provide the drugs used in the execution of a capital offender. Although many Christians believe that capital punishment is permissible, I suspect that most of them would be hard-pressed to give a good reason as to why the state should coerce the pharmacist to provide to the state what his conscience says he must not do. In conclusion, although one could argue that the Establishment Clause of the First Amendment was intended to separate church and state, even if those precise words do not appear in the Constitution, it hardly follows from this that it was intended as an epistemic litmus test by which a court or a legal theorist may capriciously sequester faith from reason. Thank you.